This is Felicia Harris.
Page 6 of the plaintiff.
Patel and I, with my partner Alexa Salin, request permission to practice under MCR Rule 8.120.
Under my supervision, Your
I
Honor.
know that part. You got the other part wrong.
What part?
Why would you say rule twice?
Oh, and
Really, why would you do that? And why isn't your partner standing? This is just, what are you teaching them at Michigan? What?
I apologize, Your Honor.
What? Dear goodness. All right, I'll let you start again. If you say MCR
Don't say rule.
rule afterwards, that's like MCR rule. Michigan Court Rule.
Is that like
That's how
VIN
it
number, Your
sounded.
Honor? Is
What?
that like VIN number?
VIN number, yeah, it's like VIN number, exactly.
I'll attribute it to the nerves. I'm not used to a YouTube live audience. I will start again. My name is Laura Patel, Your Honor. I'm here with my partner, Alexa Salin. We are requesting permission to practice under MCR 8.120 under supervision of Davis Intervention.
Permission to practice is granted. What are we doing?
So, Your Honor, this started out as a conduct case. There remains differences of opinion regarding both background and the dates and duration of Ms. Burris's employment history. We have asked for HUD determination paperwork early on in discovery and have yet to receive it. What we have agreed to with the other side is asking for a subpoena of payroll records of Ms. Burris to just better understand what the true numbers are in terms of rent owed. And we request an adjournment of 4 weeks until December 3rd of this year, Your Honor.
It's a lot there. That's the way they do it in Michigan. At Maryland, she would have said it real simple so that this little country judge could understand.
Your Honor, may I ask a question? You referenced Maryland. At Maryland, would the attorney have told you that she asked for something and I hadn't given it to her?
Did you what?
That she asked for something and I hadn't given it to her?
Yes.
Okay. I felt like I was getting told on, is why I asked. So could I give a little context?
Sure, because I'm not sure
We filed a termination of tenancy case,
Right.
which is why she referenced a behavioral issue. We're enter into a COD and we're all agreed that it'll be a no lease violations, no disturbances, no fighting with neighbors.
Yeah.
But there's an issue still out there of past due rent. We have a disagreement about the amount of rent that's owed. Rather than file another case, we've all agreed that we're going to roll the financial issue into this case. They're going to subpoena records from employer. I'm going to get the records that we have that how my client calculated rent since Ms. Burris took possession in January. We're going to put all that information together. We'd like to come back on December 3rd and see where we are. It's possible we'll have an order prepared for you before then. I think we've agreed we don't need to amend pleadings. If we end up with a trial, we'll either do an amendment of the pleadings before then or just agree that the pleadings will be amended orally to conform with the proofs.
okay, yeah,
In other words, we don't want to start a new case. We just want to try to get everything done.
and that makes sense, quite frankly. The only question I'm going to have is they're going to subpoena records from employers regarding her employment.
One employer. One employer. We do not agree on when she started or when she terminated. And if we also then get pay stubs, we'll have objective information about when she started, when she terminated, and how much she made.
Okay, maybe I'm wrong, and maybe this isn't the type of, but wouldn't that have been supplied? And that's how your client knows.
Yes.
So
They want
there's a
to.
challenge to that information?
We don't have.
Oh,
Your Honor, I don't think we need to discuss it today, but I don't have any objection to them subpoenaing the information. I was going to do it just as a way to eliminate the argument.
Got
But
it.
I'm also going to give them what we have and what we based it on. This wasn't a financial case until after,
Right, got it.
when we got to a resolution on the behavioral case.
Okay, I don't have December 3rd, correct? I do? Did they just pick the date? Or did you give them a date?
I did not give them the
They
date.
just
They
picked
got
it?
lucky.
They just assumed that I wasn't busy.
Oh, yeah.
It's her fault.
I'll take it.
All right. December 3rd, 2024, 9 a.m.
Thank you.
Thank you.
Thank you, folks. I'm not off at this point because I know.
Better have one more thing on the record on that.
Oh, sure.
Ms. Burris is going to, we've been refusing rent. Ms. Burris is going to start paying her rent directly. She'll pay November rent by next Monday. And I will communicate to make sure that the ledger reflects it. Since we were refusing rent, there won't be a late fee attached to it.
Got it. Okay.
And they're waiving Park Forest is the reason I'm bringing it up.
Good enough.
Thank you.
Thank you, folks. Thank you, Ms. Patel. Rule.
I'll put on the shirt, bring one for you.
All right. Avondale Management versus Burks. It's your appearances, please.
Good afternoon, Your Honor. Jonathan Manchek appearing on behalf of the plaintiff. Jamie Mukherjee appearing on behalf of the defendant.
Okay, so first of all, let me just state one thing, and this is directed to you, Reverend Jack. The email that you sent to my office was absolutely inappropriate if you thought this court entered into any ex parte communication whatsoever. So no, let me finish. First of all, I think what you need to do is you need to understand exactly what the rule is, because anything regarding scheduling does not fall under that. So before you make that accusation or even intimate that that is an accusation, you better be clear on your facts. Am I understood?
Sorry.
There is now a motion to withdraw as counsel on this, Mr. Mukherjee.
That's correct, Your Honor. We have motion to withdraw as counsel.
Had you received a copy of that?
I did last night. I'm not going to object.
Ma'am, is there anything you want to say regarding the motion to withdraw? Pardon? You're going to proceed on your own, or you're going to find,
I'm searching for a new attorney. And I have one who I just sent an email to today. And he's doing it quickly.
I'm sorry?
I have an attorney that I sent an email to today in regards to representing me, and I'm waiting on his response.
Pardon? Need you to state your name.
Gemma Gordon,
Your name?
Francisca Burke.
Mr. Mukherjee's motion to withdraw is granted.
If I may, Your Honor.
Yes.
Pursuant to court order, I believe counsel has escrowed some rent. I would ask that money is in his IOLTA. I would ask that be deposited with the court.
That rent is on deposit.
Oh, is it? Okay, sorry.
Pardon?
The rent's on the deposits with the court.
Escrow.
You've deposited all of it with the court?
I did. I paid
Okay.
escrow to the court for $2,300 back in on August.
So there was none paid to you?
No,
Dude,
sorry, I got.
I do have the 23.
Okay. Sorry, I was under the impression that counsel had it. So,
All right, the motion to withdraw is granted. I'll adjourn the matter out. We might as well go a month out. You said you're gonna have an attorney.
Yes, I emailed the attorney that I'm interested in having represent me. I'm waiting for him to respond to me. And once he does, I'll be able to inform the court what he will. And
Well, I don't. Okay, here's the way it's gonna work. Either you're gonna have an attorney or you're gonna proceed on your own. I'm not gonna sit there and wait around, nor have the plaintiffs wait around to try to figure all that out from your side. You had an attorney here, and that's how that's gonna work. So I'm gonna adjourn this out to December 3rd at 9. And once you, go ahead.
I have a trial in Southfield that morning, unfortunately.
Do I have the 10th?
yes, you do.
10th? Will the next week work for
Oh.
The 10th?
Yes, that.
December 10th.
That works for you and your client?
I'll move what I have that day.
Okay. December 10th, 2024, 9 a.m. So that I'm clear, ma'am. Mr. McCurdy's not going to be here. You will need to either have an attorney here ready to go who will, when your attorney should be in touch with plaintiff's counsel prior to that point in time. If you don't have an attorney, you need to prepare yourselves to go.
Yes, sir.
To be clear, Your Honor, the hearing on the 10th, because I believe today was the final settlement, correct?
That'd be a final settlement. I
Okay, all
can't.
right. I want to be clear.
Yes, it'll be a final settlement that day.
I understand that we're dismissing him, but can I make a request as well, Your Honor, please?
What is your request?
Okay, I do need, something from council stating that I am a tenant in the home,
At what?
that I am a tenant in the home still.
From who at council?
Proposed.
Here's what I'm gonna do. I'm not gonna get involved in that. All I can say is that if you have an attorney, they can do that, or you can send a written request to council and see if he will consult.
She told my insurance company that I'm not a tenant. And she has-
Ma'am? I'm not, what did I just say?
I understand.
See everybody December 10th. Thank you.
Thank you.
Thank you.